I want to welcome you to the first of this semester's series of lectures on, we're calling it this time, Diversity and Social Justice in the First Year curriculum. Last semester, as you may recall, we had a series of lectures on diversity in U.S. legal history, and this is sort of a follow-up on that, or something that we thought would be an interesting continuation of the discussion. I'm just going to say one thing about really the title of today's lecture, which Duncan will give. I gave it the lecture. No, he's not, right. Well, he is going to give it. It's just up there. I mean, it's the lecture you gave before. So after that, we'll have a discussion in which Duncan, in person, will participate. I gave this session the title drawing from something that Duncan wrote in a long time ago in which he described a certain aspect of the pedagogy of the first year, and it involved what he called hot and cold cases. And I'm not going to go through the entire. I found it extremely thought-provoking in thinking about my own teaching. I'm not going to go through the whole thing because at the end of it there's a sort of complicated argument that is not as directly connected to what we'll be doing in this series as the first part is. So what he says is, in the first year classes, you find a set of two cases fall into two categories. One are the hot cases and the other are the cold cases. The hot cases are ones in which when you read them, you have this sort of, visceral sense that a real injustice has been done. And the cold cases are the ones that you read and you can't imagine why anybody would care about them. Okay? Why am I spending time on this? So what happens pedagogically with the hot cases is that the instructor goes through the case in a way to sort of leach out all of your outrage at the injustice by showing how what you initially thought were features of the case that explained your sense of outrage actually are features that should explain why this was a perfectly sensible and desirable and just thing for the court to do. And it's worth noting that part of this analysis is, part of Duncan's analysis is, and that argument, that process is effective in part for compounding at least two reasons. One is the instructor's done it a lot and knows a lot more than you. And so knows the moves you're going to make when the instructor says, well, this thing wasn't really as outrageous as you thought it was. So you as a student are initially at a disadvantageous position. And then the second thing is the instructor is just an authority figure. And you're induced to accept what the instructor says as authority. Now, there's an interesting question of what happens at the very end of the presentation of the hot case. I sort of think of this as in sort of quasi-Freudian terms. Does the instructor then step back and say, okay, so now we've gone through all this, can we repair or restore your sense of outrage anyway? Most of the time that doesn't happen, I think. Most of the time it's left as your outrage has been leached out. With the cold cases, it's not more interesting, but there's a different dynamic. With the cold cases, what the instructor does is to take them and show that this case, I don't know, whether there's venue in the Eastern District of New York, actually when you think about it, and think about all the things that are associated with it, exposes the deepest kinds of issues of justice and institutional design in government that you can imagine. Whether venue is in the Eastern District in New York turns out to be a question about whether the government can coerce you into buying health care insurance. You didn't know that when you started this. Okay. So the idea is to take the cold case and make it hotter in some sense. And you're never going to get the emotional feel, but you will get this sense that something really important is at stake when you're dealing with this seemingly cold case, boring, uninteresting case. Okay, so that's the setup, my version of the setup for what you're going to see Duncan doing in this talk from which he gave last year, I believe. Year and a half ago, 2 years ago. Year and a half ago. Okay, so that's it.
So it would be something like this. I'm very preoccupied with the idea that the first year curriculum in contracts, property, and torts, and the way in which most of the faculty, this is an attack on my colleagues, teach contracts, property, and torts, turns out to have complicated messages or ideological implications which are, from my point of view, not good. Without calling them reactionary, they are, from the point of view of an anti-subordination program for education, they are regressive. So the basic thing about this claim is that it's a claim at a pretty low-down micro level about the way the sequence of cases unfolds and the way the cases are presented by teachers, to some extent as a result of the way case books are constructed, but also as a result of the way the current dominant mainstream tendencies in teaching basic first year questions limit and constrict what gets discussed in class with respect to cases in classes that are devoted to conveying legal doctrine. So what this is about is classes that understand themselves as teaching you contracts or property and torts, bodies of law with thousands of rules that you're supposed to be learning. The idea is that in that process, something more than the teaching of rules goes on. It's not true that you're just being taught rules, just rules, rules, rules. You're being taught policy. But the argument is the way you're taught policy suppresses racial and gender dimensions and class, very much class dimensions of doctrine. That is the implication and consequences for gender, race, class of what the rules are is obscured by the way that they're taught. And now that very abstract illustration, I want to claim this happens at the micro level, so I'm going to deal with a case which is a standard, which I don't know actually how many case books it's in. Most case books have an intentional torts section in which today intentional torts is very limited number of cases. It's usually a relatively small part of the case book, and most of it is devoted to a kind of listing of classical torts and defenses to classical torts. So I taught for many years using Richard Epstein's case book because although Richard Epstein is a very serious far-right conservative, his very politicization made his casebook a better casebook because he understood himself to be engaged in right-wing battle with the liberals. And that was great. That made the casebook often assault the liberal position in a way that was absent in most torts casebooks. But this case, I'm just going to now describe the case and then a way of teaching the case. And the case is called Koblin versus Kennedy's, Inc. And I'm going to read his statement of the facts, and then I'm going to read the holding, and then I'm going to read the two snippets of policy, and then I'm going to suggest what would be left out if you stuck to that as a student learning law in the first year. So here's the, so very important, by the way. To me, it's very important in teaching property and contracts to torts to always say what the court and the date is. So this case is decided in the Massachusetts Supreme Judicial Court in 1971. And I would say that it's very important for the students to understand that in 1971, the Massachusetts Supreme Judicial Court is one of the most liberal courts in the country, and it's very influenced by the Warren Court, which is just disappearing. The Warren Court is disappearing at the very moment that this case is decided, but it's still very, very influential. And the Massachusetts court, this is the context. The plaintiff, a 70-year-old man, 5 feet 4 inches tall, and dressed in a woolen shirt, topcoat, and hat, was shopping in defendant's store. Around his neck, the plaintiff wore an ascot, a little scarf. He had previously purchased in Filene's, another department store. Well, this is downtown Boston, by the way. Those were big department stores in downtown Boston. While trying on a sports coat, the plaintiff took off his ascot and put it into his pocket. He purchased the coat, left it downstairs for alterations, and as he was leaving the store, took the ascot out of his pocket and put it on again. At that moment, the defendant, Goss, an employee of Kennedy's, quote, loomed up, quote, unquote, in front of the plaintiff, demanded that he stop and explain where he'd gotten the ascot. As approximately 8 to 10 people looked on, the plaintiff agreed to return with Goss to the store. On the way up the stairs, the plaintiff experienced chest and back pains and had to stop several times. By the way, it's for me, I'm 72 years old, so I actually identify not with Kennedy's, the store, but with Kennedy, the 70-year-old. So on the way up, so he experienced chest and back pains and had to stop several times. When they reached the second floor, the salesman who had sold plaintiff the sports coat told Goss that the ascot was indeed the plaintiff's. The plaintiff was so upset by the incident that he required the attention of the store's nurse and was consequently hospitalized and treated for a, quote, myocardial infarct, unquote. The jury awarded $12,500 of damages for false imprisonment, and the defendant appealed. So this is the tort of false imprisonment. This is the only case in the casebook that deals with false imprisonment. When you're preparing for the exam, you have a long list of torts that you've learned in the intentional tort section, and in your list is the tort of false imprisonment. So now, what's the case going to be about? What is the doctrine you're supposed to learn? So here's the doctrine you're supposed to learn, and I'm going to read the relevant sort of holding for the technical dimension of it, so to speak. The pivotal question before us in most cases of this character, is whether the evidence shows that there are reasonable grounds for the detention. So they've already decided that given the guy, and I totally agree, what they did amounted to a restriction of his freedom of movement because he'd be scared to say no, he's blah, 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 blah. Very Warren Courty, so they're strongly identifying with the guy as the weak party in the situation. In common law, in an action for false imprisonment, the defense of probable cause, as measured by the prudent and cautious man standard, was available to a merchant. In other words, they can detain him if they have probable cause, and even if he wasn't guilty of anything, they're not liable because they didn't do anything wrong when they detained with probable cause. So, so then they say, the legislature inserted the words reasonable grounds. Historically, the words reasonable grounds and probable cause have been given the same meaning by the courts. So they say, this is the law. So you're writing down in your brief, this is the background legal rule, and then I hope you write down the defendant's argument. So the defendant's argument is, the defendant's requests for instructions in effect state that the proper test is a subjective one, viz., whether the defendant Goss had an honest and strong suspicion that the plaintiff was committing or attempting to commit larceny. The jury is going to decide that there was not a reasonable basis. So the jury is going to decide there was no reasonable basis. But before that happened, the defendant, seeing what was coming, almost certainly, had requested a jury instruction that the test should be subjective belief. And it's very plausible that there was subjective belief given the facts. So it would be easy to convince you that given what the guy saw, there was subjective belief that there had in fact been a shoplifting. And then the court rejects that. They say, the court holds that that jury instruction would not have been a good idea. The jury instruction on the basis of reasonable suspicion or probable cause is totally appropriate, and therefore the verdict of $12,500 is upheld. A victory for the little guy in a Warren Courtish context. So the doctrine that you'd write down is what the test is for false imprisonment in shoplifting cases. But that's not all there is, because the court offers a reason why that's the right outcome, a policy reason, so to speak, a non-technical reason, which is the following. If we adopt the subjective test as suggested by the defendants, the individual's right to liberty and freedom of movement would become subject to the, quote, honest suspicion, unquote, of a shopkeeper based on his own, quote, inarticulate hunches without regard to any discernible facts. In effect, the result would be to afford the merchant even greater authority than that given to a police officer. Now, those key words are from Warren Court criminal law opinions about arrest. I can't remember the name of the cases, but the inarticulate hunch, that old business, that rang totally true from, I can't remember what the Supreme Court case is, but there are famous Warren Court phrases about how police officers shouldn't have discretion to make arrests on the basis of inarticulate hunches. Some criminal procedure student should say, wait a minute, here's the case, but I can't remember what it is. So that's a policy reason. That's a reason. It's a rights-based explanation of why a subjective rule would be bad and an objective test is good. So it's not just learning the doctrine. You're also learning a way of arguing in favor of one rule rather than another, that in these subjective things, the objective one is protective of the plaintiff, and the subjective one is protective of the defendant, and you're supposed to learn to argue that in terms of rights. Some rights are going to get more, and some rights will get less. So it's not just deduction or just doctrine for doctrine. There's a reason offered for it. There's one other hint, which is a casebook note. The note is one sentence. So Epstein has put in a single sentence right after the opinion, which is supposed to make the student think about another question, but doesn't articulate it, though many of our colleagues would, I suspect, teaching this case, pick up on the note and exploit it. So the note says, in cases of false arrest, this is Epstein, what justification is there for making an innocent plaintiff bear the costs of the defendant's reasonable mistake? In other words, there's another alternative besides the subjective test and the reasonable suspicion test. The other would be strict liability for mistaken arrest of a shopkeeper. So that no matter how good reason you had to believe, even if you were totally reasonable, if you were mistaken, then the shopkeeper should be able to recover damages if the shopkeeper has a heart attack. And what Epstein is suggesting is you ought to have a policy reason for that too, for that distinction. Now, it is common in our context to do, that is an invitation to a law and economics analysis. It's also rooted in Epstein's belief in strict liability, which is irrelevant, which you would need to know to fully understand the context of the casebook. But a natural response to that would be something like this. So here's thinking about that. What would happen if we had strict liability for mistaken apprehension of the shopkeeper? Well, what would happen is it would increase the costs of the retailer. So the retailer is now going to have a choice between paying damages in mistaken cases or reducing the level of surveillance and letting more shopkeepers get away with it. And in either case, that will increase their costs, and they'll pass that cost along to the customers. So a basic factor here against the strict liability would be it's actually a conflict not between the store owner and the customer, but between this customer, the victim of a mistaken apprehension, and the rest of the customers who will have to pay more for increasing the level of protection. Okay, so that's a class. So now the critique of the class. That's a class which is totally innocent, that is, sure, absolutely. I actually sort of like the way the analytics unfold, particularly ending up with a little smidgen of economic analysis, which suggests to you that basically trying to protect people is really bad because it's going to pass the costs on to the public in general. So it would be very good not to go into this bleeding heart 70-year-old guys. Let them die on the sidewalk rather than increasing the cost of top coats to you and me. So it has a style of intervention which is familiar. And it's also teaching you to be hard-nosed, and it's teaching you an important thing, to look who's going to pay. It's really, really good to ask who's going to have to pay for this protection. That's not bad. That's law and economics at its absolute best. Here's the criticism. Now, I'm going to do this slightly anecdotally. So this is a real case book. I've taught it for many years. My attitude to it was affected by the following. When I was teaching contracts as a young guy, not 70 years old, in 1975 or 1976, a student of mine became a clerk in the Massachusetts trial court in East Cambridge, the very beautiful Bullfinch building. And he said, you don't know anything about, you've never practiced law, you know absolutely nothing about it. I demand that you come and observe a trial. So I actually complied. The building was beautiful. The trial was a civil action by a black woman, an African-American woman, against one of the stores in Central Square for falsely apprehending her as a shoplifter. So she sued for damages. I didn't sit through the whole trial. A jury had been paneled, but I heard the end of her testimony on direct, in which her lawyer asked her the following question. This is really inconvenient for you. It's obviously been a horrible experience. I didn't actually get, I don't know whether she had a heart attack, but I didn't get the full description of why she was so particularly injured that her lawyer thought he could get enough damages to make the contingency fee worth it. And she said, look, this happens to us all the time. It is absolutely constant. You go into a store and you're constantly being hassled, you're constantly being basically looked at with suspicion, and you're constantly being accused of shoplifting, and I'm just sick of it. That's why I sue. So, okay, I get Epstein's casebook, so I'm prepared by this random event, a benefit of never having practiced law and being subject to the mockery of your students as a rank amateur who had not even a member of the bar. Please let me come just look and see what it's like. Have you ever seen a judge, Professor? So this is the source of this little moment of teaching. So then, okay, now it then looks as though the choice between the reasonable person standard and strict liability has a little more significance. It's obvious that the reasonable person standard is going to be heavily subject to social stereotyping, context, and all the factors that Kim was talking about. Totally subject to that. The guy is going to claim, and if the jury is a white jury, they will be strongly influenced by racial stereotypes about shoplifting and theft. Very strongly influenced by that. It's a very weak standard of protection in a situation of strong racial prejudice, first. So the argument for strict liability is different from the argument of strict liability as I originally posed it, because strict liability looks like a plausible way to respond to the racist application of a reasonable person standard, first. So that's the first point. This case, taught this way, actually is quite different in what it's about. It's about how much protection actually given the prevalence of this racial structure to the store encounter. And by the way, it's not just a poor or a lower middle class. There's a very famous article by Patricia Williams, who I'm sure you've all heard of Shopping While Black. It's a brilliant description of shopping on Madison Avenue in high fashion stores and approaching the store and hearing the click of the lock that will then require her to request entry because she's black. So she walks down the street, she wants to go and look at a Balenciaga dress, her favorite thing, and then there's this click, and then she has to pick up the phone or do the intercom in order to get into the store. So this is not just a class issue, it's a race issue across class. So now let's talk about the economic argument. So this is the last part. So there's a distributive question. That is, the black plaintiffs have an argument that they're underprotected, that they should get more. What about the argument that it's expense of fellow shoppers? So here would be a simple distributive way of looking at it, which is not liberal. It's distributively oriented from a more left-wing point of view, and it would go like this. The people who are going to benefit are not customers in general. A rule of strict liability is, in effect, an insurance policy. It's an insurance policy for black shoppers against the harm of being falsely accused of shoplifting. Think of it as just an insurance policy. You pay for it by paying more for the goods. But the distributive argument is this. The price of the goods will be uniformly raised for everybody by a tiny amount. But the benefits will be concentrated on a particular class, not only concentrated only on a particular class, but a disproportionate number of the people who recover will be African American. So this is, in fact, a distributive legal rule. If you have strict liability, a very small increase in price that's imposed on everybody will substantially benefit the class of people who are being discriminated against in the application of suspicion by shoplifters and the reasonable person standard. So the basic argument is the case. Now, how many cases are there like this in the first year curriculum? Millions. Millions. They are everywhere. So every case book has in the list of defenses the privilege, official privilege. What is official privilege? It's not a battery if you are a police officer when you arrest someone. From that, you just have a whole segment on police brutality. So police brutality is built into the torts force that way. There's a defense of self-defense. Big question, does the battered woman have the right to kill in self-defense? You can teach the whole torts case having the race or gender dimension of every single case. That's all I have to say. Now let me say my last case. It's so fun to do my last case in this context as a last actual exercise of Harvard Law School teaching. And it's really been a great ride. And I'm very glad and thank you for listening to it. Yeah. So at this moment in American political history, this kind of stuff seems somewhat, it is very micro. It's at a very low level of engagement with the politics of the legal system in general. And I particularly want to say that although what I'm going to be saying in answer to questions is highly critical of first-year instruction at Harvard Law School, to put it mildly, I do think that it's worth reflecting on the fact that the institution, as I've known it over these 45 years, is a deeply liberal institution. And I think that it is appropriate if you feel threatened in the overall situation because you're black or immigrant identified to see the institution as likely to strongly defend you, particularly if you keep pressure on it. So in that sense, we live in a somewhat protected bubble as a result of the good faith commitment to those liberal ideals of the people who run the institution. And I think that's likely to be true of the next dean as well. The next dean will probably be much more conservative than Martha, but will almost certainly have very deep commitments to the protection of the people who are threatened by the way the Trump administration has evolved. Having said that, I think this stuff is still of interest, still highly relevant, still worth thinking about. But now let me ask a couple of questions before you ask questions. So how many of you are 1Ls? How many of you are 2Ls? 3Ls? LLMs? SJDs? Other? So that's it. So I'm open to questions on any aspect of this. This is just like for, yeah, go ahead.
So it looked like a couple of your colleagues are in this video, and I was wondering what the reception has been like, if you have engaged in conversations with other professors about maybe adopting a more critical teaching style and with the administration, and if you continue those conversations.
So the people in the video, only one of my colleagues in the video is John Hanson, who's sitting behind me. The other two people are Gary Peller and Kimberly Crenshaw, each of whom were students of mine and who are political allies in the critical legal studies movement, are among the founders of critical race theory, among other things. So the event is actually a highly political event organized by Reclaim. This is before Belinda Hall. It was organized by Reclaim as part of a teach-in to put forward one of the programmatic demands of Reclaim, which was phrased as contextualization in the first-year curriculum. And the form of the demand was, we need first-year teaching to be focused in a serious way on the implications of the basic rules of contracts and property and tort for the distribution of money, power, welfare, and dignity between the different ethnic and other identity groups in the society. So this was one of their, it always stayed in every list of demands. They had 20 lists of demands, and there were millions of demands. They came and went, as happens in all radical movements. But that demand stayed. And the demand was not for more cases with black plaintiffs and defendants. So this is a part of my critique of diversity at Harvard Law School, is that it's about things like black people need to see black faces or they'll be alienated from the whole thing. That's a liberal diversity orientation contrasted with a more left racial power orientation, which would say, we don't care whether the plaintiffs are white or black. That's totally irrelevant. We want to know what the legal structure is doing in situations where it's not about prejudice displayed on the surface of the rule structure. It's about the way the rules of property or contract or tort over time affect who ends up with what. And that case is supposed to be an example of that. So that approach, how shall I say, I've been arguing that approach for 40 years. And so my colleagues have been totally aware of that in so much as I used to mouth off in faculty meetings and generally be a nuisance. And I would say that the approach in general is very, very, it's not a matter of, this is the, lefties criticize liberals. And when lefties criticize liberals, the critical race theory dimension is critical race theory is not a liberal, it's a left of liberal tendency. So the structure of the system is oriented to a vision of diversity, which is recognition, acceptance, and endorsement, and not oriented to power. And I would say, thus hath it been in my experience.
What was the reaction, or what were or are the reactions of professors such as John Goldberg and Harry Smith to your method of teaching?
I have no idea, except to the method of teaching question, I have no idea. But Professor Smith and Goldberg are my once colleagues, represent a coherent alternative point of view to the typical more liberal point of view, which is dominant in the faculty. So the faculty has a center left, it has a center right, it has a harder right, and it has a harder left. So it's distributed in that way. And the first-year courses are a major area or field where the division between the center left and the center right is played out, but at a very, very sub-rosa level. You'd have to really be paying attention to what's happening at this micro level in order to understand what was going on. So the particular, the flip that I attended at the end of the video, which is to say a typical law and economics oriented person, Smith and Goldberg are not law and economics oriented, but I'll do that in a sec, would say is the more conservative you are, the more likely you are to argue that going from negligence to strict liability, as in the question of false arrest for shoplifting of a black person, is hurting the people you're trying to help. So this would be the hot case argument. you think it's outrageous and that she ought to be compensated. But if she's compensated, it will actually be bad for black people, because the cost of that will just be passed along, and they'll be paying more for top coats. So give it a rest. Go carry a sign somewhere else. So that structure of argument is the most law and economics-y version of it. But all across the spectrum, people will then be concerned to a greater or lesser degree. So in terms of the teaching technique, I don't think it's plausible either that so law and economics is one, and another basic idea, which is more characteristic of the new private law people, which those two professors are part of a movement called the New Private Law, which is much more rights-oriented, which would say something like, in that case, it's not consistent with our understanding of fairness at all that the store should be held liable because they didn't do anything wrong. Now, sometimes it does make it is okay to have strict liability, but your intuition here ought to be, there's something outrageous about saying that when the guy put the ascot into his pocket, what this is about is that. Who wouldn't have thought he put the ascot into his pocket, and then he took it out and he put it on as he was walking out of the store, looking at it in terms of one individual, one, quote, individual, unquote, the store, and in terms of another individual, the guy really has no reason to complain according to the normal ideas about morality in interactions in life. So I think that's the way they would respond.
Thank you. I'm interested in understanding your perspective on the ramifications of the existing approach pedagogy to 1L coursework, and why this perspective you think would be useful or valuable, whatever language you'd use for why we should also be bringing in this perspective. Are there negative ramifications for the Harvard Law students only learning a law and economics perspective?
So first of all, I have to say right away, I favor the law. I was trying to show a law and economics perspective. I believe that law and economics is absolutely crucial to any left critique of the system. If you can't answer the argument that you're hurting the people you're trying to help because the protection in private law will be passed along to the people you're trying to support, you have to have an argument about that, or you'll just be rolled under by the center right and the right. They'll make you look like an idiot if you haven't figured out how to answer the claim that a warranty of habitability in rental housing will cause the landlord to evict the grandmother and raise the rent. So if you claim to be so loving and wonderful for poor people, if you don't have an argument in answer to that, plausible middle-of-the-roaders and center-righters will successfully argument that you will hurt the people you're trying to help. If your basic argument about unconscionability is just, wow, the bargain was horrible, you need an argument to respond to the claim that if you allow the unconscionability defense in a consumer credit situation, what will happen is you're hurting the people you're trying to help because no poor person will ever be able to get credit again if they can't make those contracts. Now, there are answers to all of those things. There are law and economics arguments. The law and economics possession of that argument is a function of the division of law schools between the hard guys and soft guys, between the toughies and the humanists, between the liberals who just love everybody and are in favor of all kinds of diversity, and the stronger people who are saying, look, that's soft, that's weak, it just doesn't work. Let me explain to you what you really need is, as I said before, if you don't increase the protection, let the grandfather collapse on the sidewalk. That was the point there, was to illustrate that conflict of ethoses between hard guys and soft guys. I think the leftists and the progressives should be much harder. They should never say to what you said, which is law and economics, we shouldn't let them own it. We should own it. Because there is a totally available left-wing law and economics that deals with all of those questions. And you just have to find it. In my work, particularly. Go to my website. So what is the effect of this way of doing it? So according to me, the effect of not of law and economics, but of one-sided law and economics arguments, which are not convincing to anyone who is an economist. They're only convincing to right-wing lawyer economists. They're totally, and to first-year law students. So what is the bad effect? The bad effect is first-year law students absorb the idea that law and economics is an alien thing possessed by people who they don't sympathize with but are technically able to just slice and dice them if they try to resist, and that in some basic way, economic science is on the side of repression or non-protection of weak parties. I think it's incredibly important, and it means that throughout your professional lives, as lawyers, if you don't go into that, if you become lawyers for a bank, you'll learn the left-wing arguments against the bank's against protection of bank customers. But if you don't, then the background way these things are discussed in America is it's nice humanists versus hard conservatives. And the nice humanists just they don't hack it. So that's an argument of a profound ideological effect on race in America. Race in America is debated in a context symbolized by Williams versus Walker Thomas. How about putting it that way? So from my sort of white guy, critical race theory, sympathetic point of view, the way race is worked out in vast aspects of American culture is it's Williams versus Walker Thomas. So the race impulse, the idea is there's this question, should we rescue poor black women through a legal mechanism which would both be counterproductive, probably just hurt the people you're trying to help and end up making everything worse, and at the same time is incredibly condescendingly based on the superiority of the white judge to the black woman. So this kind of economic analysis, applied to Williams versus Walker Thomas, suggests very significant overall benefits to black communities if Skelly Wright's actual theory in Williams versus Walker Thomas was that it should be generalized across all consumer contracts. If that had won, it would have been great for black people. They wouldn't have been hurting the people they were trying to help. And the rationale of Williams versus Walker Thomas is actually economically completely sound. Although Charles Fried, my colleague, has written a brilliant chapter in Contract as Promise attacking that, I think he's wrong. So it's a very good chapter. He really does unpack the arguments why you shouldn't do it if you're a liberal. He's a right-winger arguing to the liberals that they shouldn't do something for the poor people, not because he's a right-winger and he hates poor people, but if you love poor people, you let them go to the wall in some cases in order to preserve their overall economically plausible position in the long run. So I think the argument is wrong. But I think the characteristic structure that it's all about an incredible act of the legal system takes into account extreme suffering, that's what we should be about, as opposed to the legal system should redistribute income and wealth between social groups. That's putting it bluntly. Compassion versus redistribution of wealth and income between social groups. So the argument is the private law system already does that. It distributes income and wealth between social groups. That's the fact. And you, according to me, should be indoctrinated. You should be drilled on that idea. You should be over and over again told, this is distribution. Things are being distributed. You have to decide who you want to get them. It's important how much there is. You wouldn't want to do the redistribution in a way that killed the goose that lays the golden eggs, blah, blah, blah. But if you aren't finding out who's getting the bennies from the cases that you're being taught, in this representation, you are being ideologically misled and indoctrinated in false ideas about the social totality. And they are bad for the people who would benefit if these ideas were debunked.
Yeah, thank you. To Emmanuel's point, I actually think what you're saying, the kind of false law and economics narrative, from what I've seen, I feel like it kind of dampens like any social justice spirit that, not any, but a lot of what people have coming in. So I'm wondering, I mean, one immediate solution I can think of is just making sure every professor just has like 10 minutes at the end of every case and says, was this the right outcome? And have a conversation about it, at least to voice that kind of spirit. So I'm wondering about that, and if in those faculty meetings and going forward you can think of any kind of real tangible solutions that professors might maybe have to implement or can be done through orientation or something else to kind of get at solutions to the problem that you're trying to
So on the first point, I think that idea is one that I am totally in favor of, the voting idea. So that's really, really, and I did that throughout my career, basically. In any case that seemed in any way to raise the issues of distribution, but also altruism, the different forms of moral commitment that people can have to each other, et cetera, I thought voting was an incredibly useful thing. And it was really interesting. And in fact, even better is situations in which the professor tries to pick a case which will split the class so the class experiences the case as controversial because half of the class wants it and the other half of the class doesn't want it. That brings to the fore the extent to which the legal private law system is a system that is politically controversial if you understand what's going on. So the question of what to do about this, I was hoping someone would ask this, but I have to give some answer like this. In my own experience, what we're talking about here is really, really deep. And the idea that the dean or a faculty vote would be able to seriously address it is not that plausible to me. Partly because there's an unbelievably strong sense of people who teach in the first year that their academic freedom includes, and I agree with this, because none of this analysis would be there if the institution had exercised a serious patriarchal authority over the faculty. Nothing that I've told you would be there. So basically, the idea that the dean and the administration are plausible monitors of the micro-biases, the ideological micro-biases of the system is not a plausible idea. That's never going to happen. The faculty is not going to decide to require a distinction like the distinction between moderate center-left liberalism and a harder form of leftism to be incorporated into the curriculum. I mean, that's just not a conceivable thing that could happen.
Yeah, we have to stop so people can come in. Thank you very much.
Thank you, Mark.